Hello, hello, hello. Righty. After being sick last week, I'm back. This time, I'm tired. So I want to do a little bit of celeb drama. A while back now, we saw, Carl Sandilands, shock jock extraordinaire, was dumped by his media, by the radio station he was working for, or at least some kind of media company, and he lost his sweet, cushy $8.2 million a year gig. So now he's fighting it out in court, and luckily, the federal court heard our prayers, and they decided to grace us with court documents so that we can all bask. God, I hate this bullshit. Why not just give me the federal court website? Oops, my bad. You didn't need to hear that. Either way, here we go. We have Sandilands. Oh, it's good. It's good. Sandilands and his businesses versus Commonwealth Broadcast Corporation and their businesses. Thank God. You have hot and juicy federal court gossip, and they're even going to live stream it. Hell yes. Now, this started in early May. And it's got to the point where they've essentially set the trial date. I believe they're probably going to be doing a shitload of discovery right now, would be my guess. Will we see more documents before the trial? Potentially there will be a flurry of applications toward the end as they're filing all of their evidence. I'm not too familiar with the actual proceedings in terms of what gets filed and available. And the I don't know if it's sort of piecemeal as they're discovering bits and pieces and taking witness statements, etc., or if it's all just at the very end as a dump, so that you can't then do more discovery on someone else's dump. Anyway, I'm rambling because holy shit, upcoming. Should we get a little taste scheduled for the 26th? Why don't they? Why don't they keep a history? Why don't they just like keep the VOD? Where's the VODs? Oh man. Playlists. They don't keep any of the VODs. We've got some hearings coming up, but where's the VODs? That sucks. Get it together, federal court. There's no need to. There's literally no reason to delete any of the VODs ever. Just keep them up there. We're keen. We want to see it. This is public. Hungry for justice. Alright. Woo! Now, I did do a little bit of pre-reading. Date published to website. Yes. Okay. My bad. This started in March. Most recent orders came out in April. There was a little bit of movement in May as well, as people started putting in cross claims, etc. I did do a bit of pre-reading. It is pretty interesting. Well, but so it's interesting for me. I don't know about you, but here we go. Now, when it says, so here we go. So this is addressed to the Federal Court, New South Wales. Now, when it says Dalton Sandilands, that's basically him and his business. So Quasar is a company, and then Quasar IP, which I'm guessing is some kind of intellectual property rights thing, and it's like a, you can sell a trademark license, sub-license again. There we go. Righto. So it's just saying who the respondents are, who the applicants are. They're claiming the applicants contend that the purported termination was invalid and of no effect. So they're basically saying, this company terminated my contract, and it was wrong for them to do it. They did it wrong. It was wrong for them to do it. Shouldn't be something. And so they're claiming, I guess, as part of the termination, they claimed a serious misconduct causing serious and imminent injury to the CBC business that he was given a reasonable opportunity to remedy. Here we go. This is good. Start at number 4. The purported termination was premised on Mr. Sandilands having committed an act of serious misconduct, causing serious and imminent injury to the CBC's business that he was given a reasonable opportunity to remedy. Yet no serious misconduct within the meaning of the BSA was committed. Further, and in any event, Mr. Sandilands was denied a reasonable opportunity to remedy the serious and imminent injury that Mr. Sandilands was alleged to have caused. The alleged refusal, i.e., the alleged refusal of his former co-presenter Jacqueline Henderson to ever present with Mr. Sandilands again, because CBC terminated the contract under which Miss Henderson would otherwise have been entitled and obliged to present with Mr. Sandilands again. Interesting. Now, on first pass, you'd think, okay, maybe, but the structure of the contract opens out some interesting ways that this could be worked around, but we'll get there. Further alternative, the court should declare that the purported termination was invalid because it was purportedly done as part of a course of conduct that was, in all the circumstances, unconscionable within the meaning of blah 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 of Australian consumer law. Specifically, it was unconscionable in the event, in the relevant sense, for CBC to, on the one hand, purport to require Quasar and Mr. Sandilands to remedy the alleged refusal of Miss Henderson to ever present with Mr. Sandilands again, but on the other, make such a remedy impossible or difficult by terminating Miss Henderson's BSA. Ooh. Impossible or difficult? Now, impossible. Is it impossible? Like, when I first read this, anyway, I made more when I got through into the actual contract of the thing. It gets a little bit more interesting. Oh god, there's the particulars. Almost, yeah, okay, we're getting too ahead of ourselves because the respondents do a very, very good job of breaking. Too much scrolling. Respondents do a very good job of breaking this down, because ultimately in my mind I immediately start thinking, like when I was reading through this, is it's not up to them. Like, they don't have to make it. It might be difficult in its nature because he's put Miss Henderson in a situation where she doesn't ever want to work with him again. That sounds like a situation of his own making, right? And who cares if it's difficult for them to work together? It's up to him, the one that's done the deed, to figure out how to make it possible. I also didn't buy this impossible, make such a remedy impossible, because when you read the contract, all it says is that Quasar's contracted to provide a radio show in a breakfast time slot with Kyle and Jackie O as the hosts. Nothing in there stops Kyle from subcontracting Jackie O as a co-presenter through Quasar to deliver the radio show. So it's by all means difficult because he's made the relationship strained. But impossible? Fuck no. Please. The BSA and the trademark agreement. Okay. Pursuant to the clause, Quasar was engaged to provide certain program services, including the broadcast expertise of Mr. Sandilands, in connection with the show. That engagement was for a term of 10 calendar years from 2025 to and including 2034. Under the contract, Quasar would receive a fee of $7.4 million, which is basically just to be Kyle Sanders. Right. A CADA consultancy fee of $200,000 per annum, so that's probably paying for an assistant or something. A flight allowance of $120,000 per annum. That's and contra airtime valued at $500,000 per annum. Under the trademark agreement, CBC is required to pay Quasar IP sub-license fees totaling $2 million per annum. So the actual value of this is more. So in the term, if the term continues to the end of 24, a total of more than $85 million will be required to be paid to Quasar or Quasar IP under the agreement. That's taken. I mean, that's at the bare minimum. That's at the low end. Right? Like, what if he's taking all of this consultancy, all this flight allowance, all this airtime, all this? I mean, it's already 9.4. It's like $10 million a year. Significant terms of the BSA. This is their main argument. So this is the thrust of their argument on the applicant side. Pursuant to clause such and such, CBC acknowledged the tone, style, voice, and robust character with which Mr. Sandilands has performed radio presenter services during his career, and expressed a desire that Mr. Sandilands would present in a robust character. Is this actual wording from the contract, I wonder? Potentially. Also, within the similar clause, CBC agreed to provide a censor at all times to monitor all recordings of Mr. Sandilands made in the course of the program services, to operate a 30-second delay for each broadcast, and to dump, that is not broadcast, certain material, including material that did not comply with the BSA. Interesting. So they're saying, I'm a rude prick, and that's why you wanted me, because I have an abrasive, robust character. Secondly, they're saying, you provided censors, so if I was saying something you didn't like, you should have dumped it. That's on you. By clause 5.5, CBC agreed that despite anything to the contrary in the BSA, and subject to a presently irrelevant condition, Quasar and Mr. Sandilands would not be in breach of the BSA, nor shall CBC have any rights against Quasar or Sandilands under the BSA arising out of any material prepared or presented by Sandilands under the BSA unless four conditions were satisfied. The material, unless all four were satisfied. Like this is, the respondents they'll like show that this is finally a bullshit claim, right? All is it all four? Interesting. The material was actually publicly exploited under the BSA. So they're saying Mr. Sandilands would not be in breach unless all four conditions, nor shall have any rights against. I mean, this is crazy. Like, I'm sorry, nor shall have any rights against Mr. Sandilands. So basically saying that material was publicly exploited. So anything that goes on the air, even if it's totally egregious or against the BSA or against company policy, tough shit, excuse me, Mr. Sandilands had actual knowledge that the material would or was likely to breach a term of the BSA or give rise to a claim. Excuse me? So if he's doing it maliciously, right? And some interesting evidence there. The aspect of the material that would but cause breach the BSA or give rise to a claim could not have been known by the censor or the legal clearance personnel of the BSA privy to the material prior to its exploitation. So basically saying there's a censor but they didn't know what he was going to say. The material was not material, but type referred to in clause 17.1 J, 17.1 K. So here we've got 17.1 J or K. Well, they don't even list out what they are. That's fucking wild. Anyway, clause 17.1A2 empowered CBC to terminate the BSA immediately by notice in writing if Mr. Sandilands commits an act of serious misconduct which affects or compromises the program services by causing serious and imminent injury to CBC's business, having been given a reasonable opportunity by notice in writing, referring specifically to clause this, not exceeding 14 days, to remedy same, where it is capable of being remedied. Where it is capable of being remedied. Ooh la la. I like that one. And same again, right? So the BSA empowers CBC to terminate the BSA if Quasar does the same. Right. So they're basically saying Mr. Sandin. Oh wow. Okay. So they're just not. They're saying if Kyle does it or if someone from the actual company does it, right? Sorry, no. This is serious and persistent. Oh, okay. So this is the serious and persistent part. This is another part. So they can also terminate if Mr. Sandilands commits a serious and persistent breach or non-observance of any of the terms of the BSA, having been given written notice of the relevant breach and a reasonable opportunity to remedy same, where it has been capable. So that's basically saying, look, if you do shit wrong multiple times, we notice you and you remedy it, that can be cause for cancellation. So it's not just like, okay, I fuck up and I fix it, and I can fuck up, keep fucking up and fixing it, keep fucking up and fixing it, keep fucking up and fixing it ad infinitum. If you fuck up and fix it 10 times, that is a persistent breach of the terms. You constantly fucking up. No more. That's what that says. So it sounds like he's only gotten one breach notice, and after that, failure to remedy. So this doesn't even come into play. So notwithstanding anything else, it will not be a breach of the BSA, nor will CBC have a right to terminate the BSA under Clause 17, where the provisions of Clause 5.5 operate to relieve Quasar and or Mr. Sandilands of responsibility for material which may otherwise have given rise to a right to terminate. I mean, there might have some argument there if it pertained to online sorry, what is it? Live content, where they're broadcast content. But there's also a limit, right? And we see the respondents outline some reasonable limits. Right. So we're getting a bit of the thrust of the whinge here. The whinge is basically saying, you terminated me when you shouldn't have, because I didn't do anything wrong. I was being a dickhead, and that's what I'm here for. And then saying you didn't give me a chance to make it better because you fired the one person who is in the contract that says I can do the show with. So it literally states in the contract, the show comprises of these two people. So if one of them can't do it, then the other one can't fulfill the contract. That's immediately like, okay, well, you can't fulfill your contract. I'm sorry, but you're in breach if you can't fulfill your contract. So let's terminate. Let's fucking go. So that is the concise statement. That's the. There is a statement of claim. The cross claim. Oh, I think that's the one where they're saying we're butthurt. You cost me a lot of money. Etc. 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 So they're not taking it lying down. They're putting a cross claim as well, which I mean, as they should, right? So the cross claim. So Kyle's basically saying, you owe me money, you breached, I want a whole bunch of cash. And these guys are saying, well, no. You want a whole bunch of cash too. And they want it to be ruled that they terminated it legally. On March, this much remained. The premises quasi is required to pay as debt immediately owing $2 million. And they're entitled to recover that amount of debt, and then obviously termination of other Henderson BSA. Ooh, they're trying to tack on a few things. Yeah, I like the respondents. The respondents are very good. I think they've got a reasonable case on them. So I'm getting all over the place. Statement of claim. This is. Oh my God, I'm going to have to just reopen because I can't immediately. Okay, defense. I think this is the one I want. Cross claim. That was the cross notice claimants. Cross claimants. Okay. Cross respondents. Oh, because they're the cross. Yeah. Oh my God. Righto. Statement of claim. This is defense. This is coming from, filed on behalf of CBC, prepared by Nerida Jessup, Herbert Smith, Freehills, and Kramer. Nerida doing a bang-up job here. Because immediately when I read through the statement of claim, I immediately thought, surely there is some workplace bullying going on, and you can claim workplace health and safety. And be like, nope, sorry. We have to create a safe working environment for all our employees. We're unable to do that while, we're unable to do that for Jackie O, because Carl's bullying her, so we have to terminate, give notice, terminate all this shit because it's not possible. And sure enough, they absolutely successfully came through with the goods. Let me see here. Oh, this was a good one. So, statement 6. So, claim 6 is on or about blah blah blah. So, it's just talking to particulars of the agreement and the rights to terminate, right? So, it's defining the program service, the fact that it's 2 co-hosts, etc., etc. What puts in, so in the paragraph, they admit the paragraph and say further. So they want to add some additional details. Now, program services was defined in the Quasar BSA to meet the following services which are provided by Quasar: live or recorded broadcast material, and broadcast expertise of Mr. Sandilands in connection with the program. All work necessary for Mr. Sandilands to perform in order to plan and prepare broadcast material related to the program and its promotion and the promotion of the station. Further material or services as reasonably required by CBC in relation to the program and publicly for the radio station or the program, but only where on each occasion first agreed by Quasar, including presentation of broadcasts, recording of any voice tracks, performance of original comedy skits, live reads, voicing, creation of agreed public appearances. Okay. So it clearly says in here, all work necessary in order to plan, prepare, broadcast material to the program. And so the program, they need to be, Quasar is delivering a recorded broadcast material and broadcast expertise. Why can't he just hire Jackie O under this contract? Don't know. Program defined as the program initially broadcast live on the radio station at the service times, which program is more fully described in 95, where context mix includes best of program. Okay. So they also state in the contract that a breakfast program for the radio station to be presented by these 2 co-hosts or other co-hosts determined in accordance with this agreement entitled the Jack Kyle and Jackie O Show, or is otherwise approved in writing by Quasar. It was a term of the Quasar BSA that Quasar must ensure that Mr. Sandilands complies with certain specific obligations, including to work with Ms. Henderson or other agreed co-hosts and production team toward achieving the objectives, which objective was to provide an entertaining and enlivening program to the Sydney and Melbourne markets, which is intended to achieve a consistent #1 FM rating. Interesting. Very interesting. Now, we also, so it's just going on to state very objectively in terms of items in the contract and how they're defined, how they were read, and what it means. So this is just them saying, well, you said it meant this, but I think it says it means this. So it's going into some of the history in terms of they've been together since 2005, and that it was a program branded as a breakfast time slot. That was being co-hosted them by these 2 as a breakfast time slot. It's very much integral for them to be a breakfast time slot, and then they in fact insisted that they wanted the breakfast time slot because it has the highest ad revenue generating. It is the highest ad revenue generating time slot of all radio. So here we go. In the commercial radio market, the breakfast time slot commands the highest cumulative listenership of any time slot, driven by the captive commute and in-car audiences near the time. In the commercial radio market, the breakfast time slot has a significant impact on the performance of the station throughout the day because it establishes a core audience. In the commercial radio market, breakfast advertisers pay a significant premium because no other time slot delivers a comparable combination of reach, audience engagement, and commercially attractive demographics, right? So that's why they were very clear to define that these guys have to do a breakfast time slot because Motherfucker, you're earning your keep, right? You're getting paid $10 million a year. You better earn those ad dollars, baby. So in the commercial radio market, the remuneration payable to breakfast radio presenter reflects the fact that the breakfast program has the characteristics pleaded to the ones that, paragraphs above, blah, blah. So they generated advertising, and so they're saying, on the proper construction of the BSA, which is the Basic Service Agreement or whatever, as a whole, it was mutually known surrounding circumstances of the above, the commercial purpose of the object that the parties mutually intended to be secured. Okay, secured, and these what the main thing is. Okay, the commercial purpose or object that the parties mutually intended to be secured by, amongst other terms, clauses 2 and 5 of the Quasar BSA was to obtain Mr. Sandilands' presentation of a radio program that, in the absence of mutual agreement to the contrary, was both a breakfast program and presented by Kyle and Jackie O. Sounds pretty good. Now, this response. So this response talks to the whinge that Kyle's lawyers had, or Kyle was having, where saying, but you put it on air, and it's what you wanted, and the censor didn't stop me. You had a chance to stop me when because you had your own censors there, and it was bullshit. Okay, so we read a bit of this about, CBC waiving their rights against Quasar under these certain circumstances. So let's see what respondents have to say about this. So this is basically in answer to paragraph 9 of the statement of claim. The respondents say that they don't think they've admitted any of the paragraph so much yet. Further say that on its proper construction, clause 5.5 of the Quasar BSA does not operate to exclude a breach or a right if the conduct giving rise to the breach or right would have done so irrespective of whether it was part of material prepared or presented by Mr. Sandilands. So what they're saying here, on its proper construction, 5.5 does not operate to exclude a breach or a right. So basically they're saying that you can't use this to exclude some rights or potential breaches of the contract. Otherwise, there's no point in having a contract, right? Irrespective of whether the part was material prepared by Mr. Sandilands. Okay, and here's why they explain why. Were it otherwise, clause 5.5 of the Quasar BSA would have commercially absurd result. Mr. Sandilands could engage in workplace bullying, or for that matter, more serious interpersonal conduct, such as true threats or fraud, including directed at CBC's own employees, in the course of preparing or presenting material. Correct. That conduct would, in the absence of clause 5.5, give rise to breaches of all rights under the Quasar BSA, irrespective of whether it was part of material or whether it was ever publicly exploited. It would be absurd, it would be absurd if CBC's rights in respect of such conduct were contingent upon whether it happened to have occurred in the course of preparing or presenting material. Further, CBC would have no recourse at all if the material was not publicly exploited. So I think they're leaning heavily on that. I don't think it's this B, maybe this one that they're not privy to at the moment. Further, were it otherwise, Clause 5 wouldn't have Clause 5.5 of the Quasi BSA would have the even more perverse result that if Mr. Sandilands did engage in such workplace bullying or more serious conduct in the course of preparing or presenting material, CBC's rights would be greater if CBC permitted the material to go to air, because if it dumped the material, Clause 5.5a would not be satisfied and CBC would have no recourse. So they're basically saying that if he did breach the contract and they did dump it and it was not commercially exploited under this agreement, publicly exploited, well then happy days, right? Like there's been no breach because it got dumped. So you could bully the fuck out of someone as long as they dump the material. So that's ridiculous, right? At the date of the Quasar BSA, 2 employees whose full-time role was to act as so at the date of the Quasar, ARN employed 2 full-time censors for the show. They did a whole bunch of stuff. They had to dump content that goes into the details of the dumping. On the proper construction of the Quasar BSA, the fact that a censor might hear material during the 30-second display referred to for blah 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 does not mean that it could have been known for the purposes of the subclause. Were it otherwise, the extensive proviso reflected in clauses blah blah would effectively have no operation. That is because the parties contemplate that the censor would always operate a 30-second delay. Yeah, so they go on to say that they have a 30-second dump button, but as they use it, you use up that 30 seconds until it's live, and then they somehow have to catch that up, which I don't think was fully understood, so that they can build the buffer again. So once that 30-second dump is gone, then I guess they can bleep, but there's no delay on it. So that's kind of wild. Then there's some other stuff around so clause of Quasar is still and is an exclusion clause, and so is to be construed contra pro forentum, where the ordinary tools of contract interpretation still result in ambiguity. Contra pro forentum is a legal doctrine stating that if a contract or agreement contains an ambiguous term, it must be interpreted against the interests of the party who drafted or provided it. Derived from the Latin for against the offerer. It serves to penalise intentional vagueness. Interesting. Righto. Is an exclusion clause, and is to be construed where the ordinary tools of contract interpretation still result in ambiguity. Ha ha ha. That's basically saying Quasar put that in there. I think is what they're saying, right? Because they wanted it. If you can read it and it's obscure and ambiguous, then you have to run this. You have to interpret it as contra pro forentum. Outside of all that, they deny the rest of the paragraph, obviously. Allegations under the heading of the co-presenter. Well. And now they start to talk about our good friend Jackie O. So they just establish here a lot of the same stuff, that it's meant to be a breakfast radio program, re-establishing a lot of the same stuff, right? Allegations under the heading purported notice to remedy before determination. Now, let me see if we get did we go past it yet? We didn't get there yet, but we have some juiciness. This was my okay, co-presenter, righto. This is all the co-presenter stuff. We're basically there. Okay, we're almost there. So establishing breakfast program, righto. So they're admitting paragraphs which are, I mean, some of them are just like statements of fact, right? So they're admitting statements of fact where there's no disagreement. Referring to some of the other paragraphs, they're talking about notice periods. So they're talking about that 5.5 again. They're talking about their notice that they gave, otherwise deny, totally admitting something else. And then here we go. So allegations under the heading the purported termination was invalid and of no effect. Ooh, number 16. What is the claim? The impugned conduct did not constitute serious misconduct within the meaning of the phrase in the term referred to in paragraph 7 above. The impugned conduct was conduct of a robust character of a kind that CBC contractually acknowledged that Mr. Sandilands was likely to engage in the performance of radio presenter services, and which CBC indicated to Quasar that it desired. Ooh. It was CCL 6 something. It was not conduct that constituted a radical departure from the relationship established by the BSA that was inconsistent with the continuance of that relationship or otherwise conduct capable of constituting serious misconduct for the purpose of the BSA. Our good friend Nerida claps back, claiming they deny the paragraph, say further that the conduct engaged in by Mr. Sandilands was not conduct that CBC desired Quasar or Mr. Sandilands to engage in, or conduct that was required to be performed under the Quasar BSA. To the extent that the particulars to the paragraph make an implicit allegation about the nature of the relationship between CBC and Quasar, the particulars are embarrassing. Woo! And that no material facts are pleaded to establish the nature of that relationship. Ooh la la. Then we get into the nice and juicies of it. Oh, where is okay. In further answer to paragraph 16, the respondents say that the conduct referred to therein constituted serious misconduct for the reasons set out at paragraphs 16b to 16z. Ooh. On such a date, Mr. Sandilands made comment to Jackie O about her character, reputation, professional standing, and ability to present. The 20th February conduct. A transcript of Mr. Sandilands' comments is at Schedule 2 to list events. Mr. Sandilands made comments that Mr. Henderson had a fixation with astrology. Oh yeah, where's some choice quotes. Mr. Sandilands made comment that Miss Henderson was not doing the rest of the job and everyone else in this building had mentioned it to me. And I've just said I'm not getting involved. That's a management position. I've got no problem. Okay. So, there's a bit of an upset on the 20th of February, 2026. So it's all come to a head very quickly. And then it refers back to August in 2025. Prior to the 20th of February conduct, Mr. Sandilands had repeatedly bullied Miss Henderson in the workplace, as pleaded in paragraphs 16e to T and W below. So the 20th of August 2025, there were some comments made, predominantly around astrology, I'm guessing. Miss Henderson considers, and at all interior times considered, that these comments were offensive and degrading. Particulars. Miss Henderson has pleaded that these comments were offensive and degrading in paragraph 14 of her statement of claim in proceedings, blah, 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 blah. Ooh, so she's obviously got her own lawsuit going. And so this is like, you know, it's going back through timeline. Like, here's an instance where he was bullying her. Here's another instance where he was bullying her. Here we go. So, immediately after Mr. Sands made the following off-air comments to and about Miss Henderson, ARN staff during filming. So this is like there was something here. Kyle, that's a bit rough. Like, fucking hell, I haven't done anything to fucking cop it. Too bad if it's rough. That's what I've been dealing with you for the last 12 months. Not interested, not connected. No, I'm not attacking you. No real paying attention. No, that is so unfair. I don't give a fuck. That is the truth. You want to know the truth? Here's the truth. Today's the first day you've ever paid any attention. I had to carry anything in the opener. And it's all shit. Oh, fuck off. Fuck you. Fuck you too. I'm going. Welcome to the real world. And every time I say something, get back to fucking work. Move it. All these people running around doing bullshit. And the thing that really pisses me off is every time I'm trying to do something to rescue it, she goes, well, what do you mean? Oh, I don't think. Like, it's just a fucking pathetic situation. Interesting. And it continues on. So, in 2025, there were a number of instances that they outline here, and they've got the transcripts. They have it in 4K, in your face, fully recorded, on air, off air, a whole bunch of shit. And there's multiple instances. On 15th of September, Miss Henderson, through her agent, Miss Gemma O'Neill, made a complaint of bullying by Mr. Sandilands via a telephone call to Miss her agent via telephone call to Miss Lauren Joyce, ARN's Chief Audience and Content Officers. On 16th of September, Miss Joyce sent an email to Miss O'Neill, which, amongst other things, requested that Miss Henderson provide full details about the conduct about which she complained and about her concerns, which letter stated as follows. Dear Gemma, we're following up. As you know, ARN has obligations under the Fair Work Act. Holy fucking shit, are you serious that there's laws to protect people from workplace bullying? To ensure a safe workplace, including protecting people from risks to their psychological health. Okay. Please let me know if there's anything more we can do. 16th September, Miss O'Neill responded to that email, declining to provide any further details. Okay. On the 5th of December, Miss Henderson said to Mr. Bargawana words to the effect that no further action was required from ARN in relation to a complaint made through Miss O'Neill. Okay. Now, on 21st February 2026, immediately after the 20 February conduct, Miss Henderson sent a text message to Mr. Michael Stevenson, CEO of ARN, saying, among other things, first, thank you both for checking in. It genuinely means a lot. I've had some time to think, so I've had some time to sit with what happened on Friday's show, and honestly, it still doesn't sit well with me. Kyle and I have had our differences over the years, and I can go along with a lot, but this felt different. Repeatedly saying I don't know what's going on in every break and that I've become unworkable, and suggesting that management may need to step in because so many people are complaining about my incompetence, none of which is accurate, undermined my credibility in a really public way. It felt unfair, inappropriate, aggressive, and completely unprovoked. I take a lot of pride in my professionalism and reputation, so having that question on the air was confronting, particularly with how much was fabricated. On the 26th of February, so 6 days after the incident, Miss Henderson and Henderson Media's solicitors, so her lawyers, sent a letter to CBC and ARN, the complaint letter, The complaint letter alleged that Mr. Sandilands had repeatedly bullied Miss Henderson in the workplace. Dun, dun, dun. The complaint letter included. This letter does not intend to set out all events that our client may rely on to evidence both the systemic and ongoing patterns of bullying and disrespectful behaviour towards her by Mr. Sandilands, and the repeated failure of the group to either discipline Mr. Sandilands or take the necessary action to cease and prevent workplace bullying and remove a risk to the workplace health and safety of persons engaged by the group. On the morning of the letter included, on the morning of this 20th of February, Miss Henderson was again the subject of incessant bullying from her co-host, Mr. Sandilands, on live radio. At no stage during the segment did anyone at the group attempt to stop the bullying or protect Miss Henderson from the ongoing threats to her career, character, reputation, and professional standing. During that segment, Mr. Sandilands made repeated, relentless, and factually inaccurate comments about Miss Henderson's character and ability to perform her role. Ooh, here we go. The complaint letter included. Let me see if I can find the juicy part. The group has been previously well aware, including by being notified by Ms. Henderson of Mr. Sandilands' bullying, and a review of your internal records should set out the extent of this, including the specific incidents that have been reported to date. Our client has other examples to support a claim of repeated and constant workplace bullying that she has endured at the hands of Mr. Sandilands. There was numerous witnesses to the behaviour. The mere fact that this behaviour is frequent and has been continuing for a prolonged period of time also goes to demonstrate that the group has not taken required action to act in compliance with its obligation to provide a safe place of work. That consistent and ongoing bullying has left Miss Henderson psychologically unwell and has defamed and humiliated her in a public forum that has been reported in news in a series of media rags. Disgusting. Mainstream media. Complaint letter included. Should a report be made to Safe Work New South Wales, it is now highly likely that the group will be found to have breached its duty of care to Miss Henderson by exposing her to Sandilands' bullying conduct over a prolonged period. Very serious claims from the solicitors. The group has been responsible for publishing and distributing material about Miss Henderson that is not true and has and will cause serious harm to her reputation. Therefore, this has also now caused our client to consider the issue of defamation proceedings, and there can be no doubt that the statements made will satisfy the required threshold of serious harm if judicially examined. Fuck me. Okay. The complaint letter included. The simple fact is that our client has been attacked and bullied. There is evidence of persistent bullying, which despite numerous opportunities, the group had failed to adequately address both at law and ethically. Probably true, in all honesty. The complaint letter stated, amongst other things, under the heading alternate arrangements now required by Ms. Henderson, that our client cannot continue to work with Mr. Sandilands. Boom. When your letter, the complaint letter, unequivocally conveyed the objective meaning that Miss Henderson would not present a radio program with Mr. Sandilands. The complaint letter stated our client cannot continue to work with Mr. Sandilands. The complaint letter stated direct contact with Mr. Sandilands is now untenable. The intention objectively conveyed by the complaint letter that Miss Henderson would not present a radio program with Mr. Sandilands again was unequivocal, not limited in time, and not conditional upon any future contingency. The complaint letter unequivocally conveyed the objective meaning that Miss Henderson would not in future present a breakfast radio program under the Henderson BSA. The complaint letter stated, okay, let's deal with this first one. So when your co-host's lawyers send a letter to your boss that says they will not work with you under and cannot work with you, and it's now untenable. they have no requirement to force you two to work together. Right? And if it's the result of your workplace bullying, I mean, what the fuck, bro? Okay, first, and then let's get this next one, because the two of these together make it the fait accompli, right? The complaint letter unequivocally conveyed the objective meaning that Miss Henderson would not in future present a breakfast radio program under her contract. The letter stated, our client is willing to continue the agreement as a presenter, but requires the group to propose an alternate day part, which is a time slot. This letter has been prepared on an open basis so that it can be relied on by Miss Henderson to prove continued failure by the group to comply with its numerous obligations if Miss Henderson is prohibited from continuing the agreement in an alternate day part. Wow, Miss Henderson will not be able to return until a suitable alternate day part is found. The intention objectively conveyed by the complaint would not in future present a breakfast radio program under her contract when was not limited in time, condition, and contingency. Wow. CBC terminated the Henderson BSA by written notice on the 3rd of March 2026. Ms. Henderson had prior endured instances of workplace bullying and harassment at the hands of Mr. Sandilands. Okay, so these two things are basically saying contracts are contingent upon these two doing a radio show together and contingent upon it being a breakfast radio show. Now, when Miss Henderson says, I can't do it with my co-host and I can't do breakfast, she is now not able to uphold the particulars of her contract. Basically saying, I'm not going to do the contract as written, at which point I believe they should have a right to terminate. Now, the argument will be, well, I can't do it because you allowed this workplace bullying to go on. At which point she's probably going to be suing them, would be my guess. Oh, right. So they might win. They might win on the Carl Sandilands one as the respondents, but they might. We'll have to see on the Jackie O front. Okay. Further, respondents repeat paragraph blah blah blah. Okay. 16Y. Was there a 16Y here? No. They just keep doing some more stuff. In circumstances where Quasar was an independent contractor, Mr. Sandilands had no legal relationship with CBC. Quasar dynamic nature. And then they go to say, basically in the BSA, it said stuff about, we had company policies, we had codes of practice. These were all known by Mr. Sandilands. These were provided to Quasar, and they were agreed to have been read and understood as part of entering the agreement. And he failed to meet the code of conduct. So there's a lot here. Oof, and oh my god, he talks shit about the ARN management. He talks shit about the courts, contempt of court. Oh my god, this is a good one. On the 2nd of July 2025, this is the last one I'm going to read. Okay. On 2nd of July 2025, during a broadcast of the Kyle and Jackie O show, Mr. Sandilands berated a censor for using the dump button, denigrated the censor, and complained about the censor and the law of contempt of court before leaving the show that included. By the way, guys, I had to speak to our lawyer at the station yesterday. So some of the things that have been beeped out, apparently, here's another rule that's so stupid. You're allowed to talk about anything on the TV news, and the newspapers are allowed to speculate, say whatever they want. But if we talked about yesterday that girl that allegedly cut the head off the boyfriend, right? Remember, the head's missing. Oh, that was contempt of court. I could go to prison for just talking about that. So I'm not allowed to talk about it. I've got to tell you the radio laws need to be immediately overhauled. We're constrained to all these. The following content was then dumped. Ridiculous laws and rules. Even the judge in the case. Oh, so this is the. Okay. So this is where it starts. So I've got to tell you the radio laws need to be immediately overhauled. We're constrained to all these. Okay. Now, this is the dump section. Are you ready? This is what got dumped. We are constrained to all these ridiculous laws and rules. Even the judge in the case, even the judge in that case with that is currently doing the mushroom case, got a letter from the Supreme Court threatening us with contempt of court for daring to mention it. Everyone's mentioning it. Like this is radio. Like this radio should be a reflection of society's conversations. Not some hamstrung bunch of rules familiar these grannies, and I'm talking. The following was broadcast. Okay, so the show got dumped in the middle of a planned discussion that I'd already discussed with the legal team about things that have been happening on the show. Why was that dumped, censor, when I was using all the correct lingo? You panic dumped it, didn't you? Well, what's happened there? Because we're live now, can't get dumped. I was given, this is the censor talking, I was given instructions by someone else. Mr. Sandilands. Who? Censor. He's with you now, I believe. Mr. Sandilands. No, Bruno. You're saying? Don't hide things. Censor. Yes. Mr. Sandilands. Well, that's ridiculous. He sent you a message, did he? Saying dump the show. That's why he's run out the bathroom. That's why he's run out the bedroom door like a coward. Is that what's happened? Censor. Well, I don't know what he's doing right now because I can't see his video feed, but possibly. Oh my god, when it goes on, this is crazy, insane shit. Fuck, it just goes on, man. Like, what a rambler. Alright. Good times. Good times. Can't wait. So, problem is, I think trial was set for, I believe, October. So what's this? Dates 22nd to 26th of June be provisionally reserved for the hearing of the proceeding. That could be nice. I think that's for the cross claim though, right? Case management. This is just case management. Okay. This is just telling. Okay, here we go. Proceedings. Blah 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 blah. Be listed for hearing commencing on the 12th of October 2026 for a period of 10 days. So October 2. Thanks, Stuart. Thanks, Stewie. Big Stew. Alright, fuck it. Time to go. Peace out.